I've been asked to answer two questions today. The first question is whether parking a truck in the middle of the street is protected by the charter. And the answer is potentially. There are at least two provisions in the charter which could protect this type of activity. The first is Section 2B, which guarantees freedom of expression, and the second is Section 2C, which guarantees freedom of peaceful assembly. Now, we have a lot of case law on Section 2B and what constitutes freedom of peaceful expression, and the Supreme Court of Canada has defined the scope of this protection quite broadly, such that virtually any non-violent activity is going to receive protection under Section 2B. So I don't think there's much doubt here that what was happening, at least insofar as it was non-violent, was protected by Section 2B. When it comes to Section 2C and the Charter's guarantee of freedom of peaceful assembly, that's where we have a little bit less guidance. The Supreme Court of Canada has to date not issued any major rulings on freedom of peaceful assembly, and so it's not quite clear what precisely this provision protects. We know that the assembly in question has to be peaceful, so again, there's a presumption there that it has to be nonviolent. That could be interpreted more broadly to also apply to the extent to which assembly is disrupting certain activities. But I think a case can be made here that at least initially, and at least for parts of the convoy, the activity received some sort of expression under Section 2B and Section 2C. Now, the real question is going to be whether limitations on those activities were demonstrably justified under Section 1 of the Charter. And this is where we get to the heart of my answer, which is that the Charter could have potentially protected parts of the convoy for part of the protest. Certainly, initially, and again, to certain parts of it, it would have been more difficult to justify a complete and total restriction on the convoy. That justification, however, would have increased as the convoy went on and as it became clear that certain protesters were not just there to make their voices heard, but were there to stay and were essentially there to occupy the streets of our nation's capital for an indefinite period of time. Now, this leads to the second question that I was asked to answer, which is whether Ottawa police needed to let the convoy into the city. The Supreme Court of Canada, in a case from 2000, talked about this concept called the doctrine of prior restraints. And in essence, what a prior restraint is a censoring of expressive activity primarily. But in this case, we might also apply it to a peaceful assembly before it happens. And while the Supreme Court said that prior restraints can take place in certain cases, the bar for justifying them under Section 1 is going to be particularly high because it is a very severe type of limitation. Because with a prior restraint, essentially what's happening is that we are stopping the expressive activity before it happens based on our fear of how that expressive activity is going to be exercised. And so typically the norm is to punish the negative effects of the expressive activity after it has taken place, or to take steps after the fact to mitigate the damage caused by that. But to place what is essentially a total prohibition on the activity before it happens is a very severe limitation on freedom of expression, and perhaps in this case as well, freedom of peaceful assembly. So I think it would have been unwise for the Ottawa police from a legal perspective to have simply stopped the convoy from entering into the city. From a practical, political perspective, I think it also would have just exacerbated the situation and made things worse. But at the same time, I don't think that should let the Ottawa police off the hook either based on what subsequently happened. Certainly, there could have been steps that they could have taken well short of needing to ask the federal government to invoke the Emergencies Act. That would have prepared the city a little bit better for what was coming. That would have perhaps cordoned off certain streets to ensure that participants in the convoy weren't able to come in and weren't able to essentially set up this little encampment and occupy the city for weeks on end. So there were steps that could have been taken, I think, to have helped ensure that the convoy, when it came in, was able to meet its initial objectives of having a protest, as literally thousands of other groups have come into Ottawa to do before, but then to also ensure that after that initial weekend or after those first few days, that it started to wrap up and move on, as is the norm for these kind of activities.